So, if everyone can see the PowerPoint. And as I mentioned, that for substantive obligations, there are a number of different institutions right now that are actively working on reform efforts. Some of these reform efforts are more focused on procedure, but a few are focused on substance. And even reform efforts that are focused on procedure, there is still an opportunity for interaction with substantive obligations. The first reform effort that I'm sure you all are familiar with is UNCITRAL Working Group 3. This started about 5 years ago. As I will discuss, it is focused on procedure, but some of those procedural reform efforts do have a substantive dimension to them, and so I'll discuss that. UNCTAD is actually engaged in substantive reforms, coming up with draft provisions that could be used as states think more about the transition to sustainability. The OECD very recently has started a public consultation on investment treaties and climate change. So this is a reform effort that certainly is focused on substantive reforms with a particular interest in climate change. And then, as I'm sure you're aware, ICSID just completed its reform of its arbitration rules. These are procedural in nature rather than substantive. I'll just share a few thoughts on the ICSID reform process. To start with UNCITRAL Working Group 3, as you can see on the slide, the working group made a decision at the very beginning of their reform effort that they would focus on procedural aspects of ISDS rather than the underlying investment protection standards. And the reason why UNCITRAL decided to focus on procedure rather than substance is, as you can see on the slide, they observed that any proposed reform with respect to substantive obligations would be, they had doubts about whether substantive reform would be feasible and achievable. You can see that the UNCITRAL process is government-led, it is consensus-based, and so to attempt to reach consensus on the reform of substantive obligations was considered to be too much of a challenge. And so instead, the focus has been on procedural reforms. But as I have listed here, a number of these UNCITRAL procedural reforms could be seen as having a substantive dimension. The first would be the establishment of an advisory center. An advisory center could play a number of different roles, and some of those roles might include working with governments in terms of capacity building, treaty practice, working with governments on treaty drafting. So certainly the work of an advisory center could have a substantive dimension in terms of advising governments on their treaty practice, perhaps even assisting governments with the defense of claims. So the details regarding an advisory center would still need to be filled in, but there's certainly potential that an advisory center could have an impact on substantive reform. I would also highlight, you can see of these various concrete reform elements that UNCITRAL has identified, you see the reference to reflective loss and shareholder claims. This again has a substantive dimension because these are important issues about to what extent can a shareholder bring a claim where their alleged harm is harm that was directly suffered by the corporation, but has been indirectly suffered by the shareholder. To what extent can those kinds of claims go forward under investment arbitration? And so again, even though this is a procedural reform involving reflective loss and shareholder claims, it could have a substantive dimension. And then the selection and appointment of ISDS tribunal members, I think one substantive element there would be, to what extent do we want to expect, do we want to require ISDS tribunal members to have expertise in public international law, expertise with the application of these kinds of obligations. So again, even though UNCITRAL is focused on procedure, many of these procedural reform elements do have a substantive dimension. Next, we have UNCTAD, which is developing an international investment agreements reform accelerator. And the aim of this reform accelerator is to expedite the modernization of the existing stock of old generation international investment agreements. And UNCTAD has identified a number of areas for reform, areas specifically targeting substantive provisions. So in the area of substantive reform of investment arbitration, this UNCTAD effort is quite notable. And I just mentioned the possibility of an advisory center through the UNCITRAL Working Group 3 process. This UNCTAD initiative is interesting because UNCTAD has identified a way forward in terms of different directions that UNCTAD could go in supporting these reform efforts. And one direction that UNCTAD has proposed has been to provide technical assistance, to provide capacity building for governments that are considering different reforms to their own treaty practice. And so in that sense, UNCTAD already is well positioned to play a role that could be quite similar to a role that would be played by an advisory center, which again is being contemplated as part of the UNCITRAL working group process. And in terms of the 8 specific provisions that UNCTAD is focused on, you can see on the slide here that these are substantive provisions. In fact, many of these provisions I will be discussing in some detail today. We have national treatment, we have most favored nation treatment, fair and equitable treatment. I will be discussing all 3 of those obligations. UNCTAD is also focused on indirect expropriation. Notice that UNCTAD claims that reform is needed with respect to indirect as opposed to direct expropriation. And this is a distinction, as I walk through some of the treaty practice, this is a distinction that is often being highlighted in the treaty practice, is this distinction between direct and indirect expropriation, that a direct expropriation is when title is actually taken by the state. Indirect expropriation, there is no transfer of title. Rather, you have normally regulatory action, but the argument that the claimant is making is that governmental regulatory action has had an impact that is equivalent to the taking of title, that through government regulation, a particular investment has become worthless, and because the investment has become worthless, the effect is equivalent to an actual taking of title. You see that UNCTAD also mentions public policy exceptions, and as part of my talk today, I will share a few thoughts on different exceptions that are being seen in the treaty practice. The OECD is another institution that is looking at investment arbitration reform. This is a very recent initiative, really just this year, 2022. You can see that the OECD has launched a public consultation on investment treaties and climate change. And just last month, the OECD published a compilation of submissions received from stakeholders addressing the relationship between investment treaties and climate change. This was undertaken in response to a 2022 report issued by the UN Intergovernmental Panel on Climate Change. And in that UN report, the panel expressed concerns about ongoing support for fossil fuels. And as part of that report, they highlighted the role that investment treaties and investment arbitration might play in continuing to provide a kind of support for fossil fuel development. And so in response, the OECD is working on providing governments with what they call fresh ideas for governments to help governments align their investment treaties to address the climate emergency. And in this April 2022 set of documents that were just published, I have on the PowerPoint, I've highlighted language from one of the submissions. There are a number of submissions, and you can see that in this submission, there is an emphasis on what's known as green investment. And I think that there's a lot of attention right now being given to this idea of green investment. And we can see that different voices are arguing that green investment should be treated differently, should be given priority over investment that does not qualify as green investment. So as a policy matter, if governments are going in the direction of treating green investment differently, that's going to make the definition of green investment very important. That if we have just this kind of binary relationship where an investment is either considered green or not, then it will be very important for investments to attempt to fall on the green side of the line and to be able to access whatever better treatment might be available for green investment. So I think that as policymakers are focused on climate issues, focused on green investment issues, how policymakers ultimately define green investment is going to become a very important issue. For the ICSID arbitration rules, these are pretty much purely procedural. One that is very significant is the requirement to disclose third-party funders. So that is a substantial innovation in this new set of rules. The provision on ancillary claims, on counterclaims, there are some slight changes in language in that provision. I would highlight ancillary claims and counterclaims more because of the connection between potential counterclaims and investor obligations. As part of my talk today, I will be discussing investor obligations. This is a recent development in treaty practice where we're now in many investment treaties, we see not only obligations that run to governments, we also see obligations that run to investors. And so as more treaties include different kinds of investor obligations, that does create new opportunities for governments to consider bringing counterclaims, that when a claim is submitted against a government might want to consider bringing a counterclaim alleging a violation of one of the investor obligations in the treaty. In terms of efficiency, the new ICSID arbitration rules also are placing time limits on the issuance of awards. This has been a significant issue for a number of years, that awards have taken too long to be issued by tribunals. So now ICSID is placing more pressure on tribunals to issue awards in a timely manner. So that is just a broad overview of the role that a number of different institutions are playing in reform efforts. Again, some of these reform efforts are more procedural, others are more substantive. When we're looking at substantive developments, I think the treaty practice is really where we see a lot of creativity, a lot of experimentation, a lot of, as I'll discuss, what's known as treaty propagation, the idea that provisions in one treaty can inspire similar provisions in other treaties. And so in my discussion of treaty practice, I'll be covering 6 issues. The first 4 I think of as kind of a core set of substantive obligations: national treatment, MFN, fair and equitable treatment, and expropriation. Then, as I mentioned, I will turn to investor obligations, which is quite a new area that's being developed. And then finally, I'll share some thoughts on exceptions. We see a lot of recent treaty practice addressing exceptions, and I'll include a few thoughts on a recent case, 2021, Eco Oro versus Colombia. It has received a lot of attention, a lot of criticism because of how the majority in that case applied a general exception that was providing regulatory space for environmental regulation. So I will be sharing a few thoughts on that Eco Oro decision in the context of the discussion of exceptions generally. On national treatment, when we think about regulatory space, the element of in like circumstances becomes very important. As you can see, this is just one national treatment provision from the CPTPP, the Comprehensive and Progressive Treatment or Agreement for Trans-Pacific Partnership. And in the CPTPP national treatment provision, we see a series of elements that we need treatment that is no less favorable than a government accords to its own investors. But notice that the investors must be in like circumstances. So when we think about elements for national treatment, again, we need treatment. The treatment needs to be no less favorable than what is accorded to other investors. But those other investors must be in like circumstances. And in terms of regulatory space, that in like circumstances becomes a very important element in terms of providing governments with regulatory space. In very simple terms, like circumstances provides a government with the regulatory space to treat different entities differently. And for the government, a government can treat different entities differently without violating national treatment, as long as those different entities are not in like circumstances. So determining the content of this like circumstances standard becomes very important. And we see in recent treaty practice that governments are providing more and more guidance to tribunals about how the like circumstances element should be applied. And we see that the CPTPP includes a footnote. And so for those of you who have spent some time reviewing recent investment treaty practice, you've certainly seen some of these for greater certainty footnotes, these clarifying footnotes. And so here we have in CPTPP a clarifying footnote on like circumstances. And so you can see that in this footnote 14, that for greater certainty, whether treatment is accorded in like circumstances depends on the totality of the circumstances, including whether the relevant treatment distinguishes between investors or investments on the basis of legitimate public welfare objectives. So you can see that in this footnote, the drafters, the CPTPP drafters, are making clear that when a government is pursuing legitimate public welfare objectives, it has the regulatory space to treat different entities differently. And so here you see in the footnote, the drafters drawing a clear connection between regulatory space, between the pursuit of legitimate public welfare objectives and the in like circumstances element. In addition to this footnote, the predecessor agreement to the CPTPP, The Trans-Pacific Partnership, the TPP developed what they called a drafter's note on interpretation of like circumstances. And this drafter's note is actually a document that is a couple pages long. And first of all, I think it's interesting to highlight this use of a drafter's note. This is not something I have seen very much in investment treaty practice. This idea that the parties to an investment treaty, in addition to including footnotes, clarifying footnotes, for greater certainty footnotes, that it is another option to include a longer note, a longer addendum, which might be called a drafter's note. And in this drafter's note, the TPP parties provide a lot of detail on their understanding of the like circumstances element. They cite to a number of NAFTA decisions where NAFTA tribunals have applied like circumstances in different contexts. And you can see on the slide that when introducing this drafter's note, that the parties set out that this note has been prepared to ensure that tribunals follow the existing approach set out below. And so then after this introduction, in the drafter's note, we then have a couple pages of guidance on the like circumstances element. Some of that guidance tracks the guidance that you saw in the footnote, in particular mentioning the need to achieve or to pursue legitimate public welfare objectives. The drafter's note also mentions the applicable legal and regulatory frameworks. So remember the overall guidance that we want to consider all relevant circumstances. And so when we're considering all relevant circumstances, we might be thinking about the legal framework, the regulatory framework, the extent to which the government was pursuing legitimate public welfare objectives. So here we have examples of the kind of detailed guidance that's being provided. And this guidance is in part a response to a number of arguments that have been raised by claimants in investment treaty cases, where a familiar argument that is made by claimants with respect to in like circumstances is that if they are in competition with the relevant comparator, and so for national treatment, for most favored nation treatment, this concept of a comparator becomes very important, that the claimant needs to show that they are in like circumstances with some comparator. So for national treatment, the comparator is a host state national. For most favored nation treatment, the comparator is a third state national. So here we see that claimants, as I mentioned, have sometimes argued that the relevant comparator, their alleged comparator, is in competition with them. And because they are competing, that is enough to satisfy the like circumstances element. And so with this kind of guidance from governments are clarifying that a competitive relationship is only one of many different factors that should be considered when thinking about in like circumstances. That yes, we can think about competition, but we should also think about the legal framework. We should also think about the regulatory framework. We should also think about legitimate public welfare objectives. And this guidance in the drafter's note, they also mention a few different cases. And one in particular I would highlight is the drafter's note mentions the ADM versus Mexico case. And in ADM versus Mexico, the tribunal observed that that national treatment, a violation of national treatment, requires discrimination on the basis of nationality. So this is another clarification that's being provided in the drafter's note, is that a showing of nationality-based discrimination is required. And on that point, I would just observe that when I was working for the US government, I worked on a number of cases where this issue would come up in terms of national treatment. Is there a requirement to show nationality-based discrimination? Because when you look at the treaty provision does not clearly state that the discrimination must be on account of nationality. And what we have in response, again, in this drafter's note, is clarifying in the note that yes, the discrimination must be based on nationality. And I raise the issue of, for policymakers, might it be a good idea to say that directly in the treaty, to say that directly in the national treatment provision, just to remove any doubt that a violation of national treatment does require a showing of nationality-based discrimination. So again, I think generally the use of this drafter's note is an interesting innovation, and we see that this particular drafter's note is really highlighting the importance of the like circumstances element, again, to preserve regulatory space for governments in a national treatment context. There's additional guidance on like circumstances in other treaties. Here, this is from the Morocco-Nigeria bit. So we see the basic national treatment language, but then Morocco-Nigeria provides in the treaty itself. So notice this is not in a drafter's note. This is not in a footnote. This is right in the text of the treaty. We have very detailed guidance on like circumstances in this provision. And so we can see that the guidance from Morocco and Nigeria is that when a tribunal is applying like circumstances, they should be considering a number of different factors. And so here you can see 5 different factors that are listed. You also see that the language of including but not limited to. So this is an open-ended list of factors that we have. So again, this is very detailed guidance being provided by Morocco and Nigeria in terms of all of the different factors that a tribunal should consider when applying like circumstances. And again, this makes absolutely clear that like circumstances analysis should include far more than simply considering whether or not 2 entities are in a competitive relationship. I'll turn now to most favored nation treatment. When turning to most favored nation, on the one hand, national treatment and MFN, they're very similar obligations. As I mentioned, really the only difference between national treatment and MFN is the comparator, that as I mentioned with national treatment, the comparator should be a host state national. With most favored nation treatment, the comparator should be a third state national. So in that sense, national treatment and most favored nation treatment, okay, with both obligations, we're thinking about the in like circumstances element as being very important for regulatory space. But what has happened with most favored nation treatment is that the jurisprudence has really gone in a very different direction with most favored nation treatment, very different from what we think of as conventional national treatment claims, that claimants are using most favored nation treatment in a very different way. And to really clarify this point, I think we need to keep in mind the basic concepts of treatment. We need to have treatment, and that treatment is accorded by government measures. So government measures, the term measure is often defined in investment treaties. And a measure will normally include regulations, statutes, judicial decisions, administrative decisions. These can all be measures. And in a national treatment context, we often see national treatment claims that are arguing national treatment in what I think of as a conventional sense, that the government adopted some measure, some statute, regulation, administrative decision, judicial decision, and that government measure has accorded treatment to me, the foreign investor, that is less favorable than the treatment accorded to this host state investor that is in like circumstances. So that's just kind of a conventional understanding of treatment and of measure. But with MFN, with most favored nation, the understanding of treatment and measure is very different, because the treatment at issue with MFN, with this use of MFN, is treatment in the form of investment treaty provisions. And so when you think of a government according treatment, that in this context, the government would be according treatment to an investor when the government sits down at the negotiating table with another government and they're negotiating a treaty, that the theory would have to be that when the government negotiated the treaty with this other government, that agreeing to a provision in the treaty was according investors treatment. And as I mentioned, treatment should be accorded through the adoption and application of a measure. And it's not clear to me in this context, when a government is negotiating an investment treaty, what exactly is the measure? I suppose we could view a particular investment treaty provision as being a measure, but to me that doesn't quite match up with a more conventional understanding of measure, where again, a measure normally is a regulation, a statute, an administrative decision, rather than a treaty provision that one government is negotiating with another government. And as I'll discuss in a moment, in the recent CETA agreement between Canada and the EU, the CETA agreement actually provides helpful guidance on how we should think of treatment, how we should think of measure in an MFN context. But before turning to CETA, I first want to walk through a few what have become known as Maffesini provisions. And these provisions are referred to as Maffesini provisions because they are responding to a case called Maffesini versus Spain. And in that decision, that was really the first time that a claimant was successfully able to use an MFN provision to import a provision from another investment treaty that it argued was more favorable. And so the argument was that more favorable provision in the other treaty was granting better treatment to investors from third states than the treatment that was being accorded to the claimant. And the provisions at issue in Maffesini involved a waiting period in terms of how many months an investor would have to wait before submitting a claim to arbitration. So there was an 18-month waiting period under the treaty that applied to the arbitration. Under the other treaty, the treaty that was allegedly providing more favorable treatment, the waiting period was only 6 months. And so the claimant's argument was, oh, a waiting period of 6 months is better treatment than a waiting period of 18 months. And so I want to take advantage of that better treatment. And so through use of this most favored nation provision, I can import the better treatment into the treaty that I have access to. So we have seen in a lot of recent treaties responses to this kind of use of MFN. So you can see that in the RCEP agreement, with RCEP, of course, a Pacific Rim mega regional, which just entered into force at the beginning of 2022, we see that for greater certainty, the treatment referred to in the RCEP most favored nation treatment provision does not encompass any international dispute resolution procedures or mechanisms under other existing or future agreements. So this is responding directly to cases like Maffesini, where claimants have been able to argue that a dispute resolution provision in another treaty accords better treatment than the applicable dispute resolution provision in their own treaty. So again, we see use of these so-called Maffesini provisions to exclude from the scope of treatment, because remember that most favored nation treatment, the scope of MFN only applies to treatment. So what is the relevant treatment here? The relevant treatment does not include dispute resolution provisions in other investment treaties, so responding to the Maffesini decision. As I mentioned, the CETA agreement goes a step farther by addressing not only procedural provisions in other treaties, but also addressing substantive obligations in other treaties. And this approach, I think, is quite noteworthy, because what we've seen in a lot of recent treaty practice is the use of these so-called Maffesini provisions. What we have not seen very much of is governments arguing governments clarifying the relationship between treatment for MFN and substantive obligations in other treaties. So for example, and I'll be discussing that there has been such active treaty practice in the area of fair and equitable treatment as one example. So governments need to think about if in one of their treaties they have a minimum standard of treatment provision or a fair and equitable treatment provision that arguably provides better treatment than the FET provision in the applicable treaty, there is the risk that a claimant might attempt to use MFN to import the fair and equitable treatment provision that is seen as more favorable. And we really have not seen many governments addressing this aspect of MFN. Again, so there has been a lot of attention on use of MFN to import procedural provisions, but there has not been much attention on use of MFN to import substantive provisions. So here we see in the CETA agreement, first, this is just the basic CETA language on MFN. But then in the next slide, what we have is a for greater certainty provision. So again, clarifying what do we mean by treatment? What is the scope of treatment for MFN purposes? And we see that first, this CETA provision does address procedural provisions in other treaties. And so there we do have a kind of Maffesini element to this provision. But then the following sentence goes a step further. And so the next sentence goes beyond procedural provisions to address substantive obligations. And so we see the language here that substantive obligations do not in themselves constitute treatment, and thus cannot give rise to a breach of this article absent measures adopted or maintained by a party pursuant to those obligations. And as I mentioned, I think this is a really helpful clarification in the CETA agreement, that when a government sits down with another government to negotiate an investment treaty, and when the negotiation includes substantive provisions and the language of substantive provisions, the text of a substantive provision in a treaty is not in itself treatment within the meaning of treatment under MFN. Rather, as this provision clarifies, to have treatment, as I mentioned, to have treatment, we must have a measure. We must have a measure that accords treatment. And so here, the drafters are making clear that if we have a statute, a regulation, an administrative decision that is applying the treaty provision, that, okay, now we can focus on how the regulation, how the statute, how the administrative decision, we can focus on how that measure applied the provision. And so now that we can identify a measure and we can identify treatment, now we are within the scope of the MFN obligation. But if we're only looking to a substantive obligation as it exists in a treaty, without any connection to some government measure that is implementing that obligation in some way, then we are beyond the scope of treatment as treatment is understood under the MFN obligation. So again, I think a very helpful clarification in the CETA agreement. Yet another policy option with respect to MFN is to simply drop the obligation entirely. And so here, one example is the Brazil-India Investment Cooperation and Facilitation Treaty, which includes a number of obligations. So you see treatment of investments, so that's a kind of minimum standard of treatment, national treatment. But notice, we have national treatment, we have direct expropriation, we do not have most favored nation treatment. And as a policy matter, I think we're at a point now that for policymakers, this is an option to be considered. And the reason why I say that is that what I've seen in the jurisprudence is I do not see investors using MFN provisions in what I think of as a conventional sense, again, with a conventional measure. Occasionally you will see that kind of conventional MFN claim, but I would say generally those claims are rare. And I'm not aware of a conventional MFN claim that has been successful, that instead, where we have seen a lot of successful claims is in this very different use of MFN. Again, that when MFN is used in this alternative way of importing provisions from other treaties. And so I think for policymakers, if we come to the conclusion that MFN is really only being used in this alternative way, and that it's an alternative way that perhaps we don't place as much value on, then I think that raises the question of, is it simply a better approach to drop the obligation entirely? And so again, that is what we see in this one Brazil-India Investment Cooperation and Facilitation Treaty as an interesting policy option to consider. Okay, so I'll turn now to fair and equitable treatment. sometimes referred to as the minimum standard of treatment. For my talk today, I'm not going to get into detailed discussion about the minimum standard of treatment, which often includes both fair and equitable treatment and full protection and security, and a debate that often occurs in terms of whether a given fair and equitable treatment provision is a so-called autonomous provision, which is separate from customary international law, or whether it's a provision that is tied to customary international law. I'm not really going to get into those issues today, but I do want to walk through some of the recent treaty drafting on fair and equitable treatment, where you see different governments providing a lot more guidance on the content of the obligation. And to start, you see in the CETA agreement that we have paragraph 1, each party shall accord fair and equitable treatment and full protection and security in accordance with paragraphs 2 through 7. Now, note that in a lot of older treaties, you would have either a minimum standard of treatment provision or a fair and equitable treatment provision that in terms of length might look something like this paragraph 1, where the language might simply be, okay, you need to provide, a government must provide fair and equitable treatment and full protection and security, full stop, with no additional guidance. So a clear trend that we've seen is now in the more recent treaties to provide much greater levels of specificity, greater levels of guidance for tribunals with respect to the content of the obligation. So in terms of the guidance under the CETA agreement, I'll just turn to the next slide. And so here we can see in this paragraph 2, now we're being given a lot of guidance with respect to the content of fair and equitable treatment. And in investment treaties, whenever I see a list like this in an investment treaty, the first question that comes to mind is this a so-called open list, or is this a closed list, or what's sometimes referred to as, is this an illustrative list, or is this an exhaustive list? And as we get to the last provision, 2F, we see that F provides that fair and equitable treatment includes a breach of any further elements of the obligation that might be adopted by the parties to the CETA agreement in accordance with paragraph 3, and I'll turn to paragraph 3 in a moment. But for now, I would just highlight that because this provision leaves the door open to further elements, we can think of this provision as providing an open list, an illustrative list, where we have the elements set out in A through E, but then we have in F an open-ended category of potential further elements that could be added at some later time. Now, just briefly walking through A through E, first we have denial of justice. And I think that when there are debates about the content of the minimum standard of treatment, I think one point that pretty much everyone can agree on is that at a minimum, the minimum standard of treatment includes the obligation not to deny justice. And keep in mind that the denial of justice obligation, it is an international obligation. It requires more than what we might think of as a denial of due process under domestic law. That the international denial of justice obligation is more demanding. You need more of a fundamental systemic failure of the justice system to be able to establish a denial of justice. But again, not at all controversial to include denial of justice within the minimum standard of treatment obligation. And notice in B, we have a fundamental breach of due process. And the use of fundamental is making clear that an ordinary breach of due process is not going to violate fair and equitable treatment under this treaty, that no, it is only a subset of that category. It is only certain breaches of due process that rise to the level of fundamental breaches. It's only those kinds of breaches that will constitute a violation of fair and equitable treatment. Now, it is interesting that the drafters have included both denial of justice and fundamental breach of due process, simply because, in my view, there would appear to be quite a bit of overlap between A and B, but the drafters have chosen to separate out denial of justice and then fundamental breach of due process. C, you have manifest arbitrariness. So notice again the use of the adjective, the use of manifest, that if we have arbitrary government action in an ordinary sense, that's not going to violate fair and equitable treatment. Rather, the arbitrariness must be manifest. So adjectives like fundamental, like manifest, these are reinforcing what's known as a threshold requirement for the minimum standard of treatment for fair and equitable treatment, that that you might be treated unfairly in an ordinary sense, but it's only when that treatment rises to a certain threshold, rises to an international level, that the treatment can be seen as actually violating the international minimum standard of treatment. D, we see discrimination, but notice again the adjective, on manifestly wrongful grounds. E, we have abusive treatment of investors. And so here with E, I would just highlight, this is an aspect of the minimum standard of treatment where you have very interesting overlap between investment law and human rights law, because within the minimum standard of treatment, one obligation that is contained within the minimum standard is abusive treatment of individuals, of persons. And in fact, the Neer versus Mexico decision from the 1920s, which a number of governments often cite to the so-called Neer standard, which sets out a very demanding standard for a violation of the minimum standard of treatment. The Neer case involved the mistreatment of a person, of a natural person. And so just to make the point that for those who might be interested in the intersection of investment law and human rights law, that the minimum standard of treatment is a very interesting area, because again, the minimum standard does include this human rights component of the abuse of natural persons. And having mentioned the Neer case, I think it's helpful to point out that where we are today with respect to fair and equitable treatment is, I think you have a spectrum of views that on one side of the spectrum, which tends to take a very conservative view of the minimum standard, would be a number of governments who would cite the so-called Neer standard with approval, that under that Neer standard, for government action to violate the minimum standard, the government needs to have acted simply egregiously, if not in bad faith, that a very demanding standard for a violation of the minimum standard. And then on the other end of the spectrum, you have many investors who argue that being treated unfairly in an ordinary sense, that can be enough to violate the standard. And so I think what we've seen in a lot of the recent treaty practice is governments clarifying that in their view, that the content of this obligation is somewhere in between those two poles, right? That it's something more than the very narrow standards set out in the near case, but of course it's something less than unfairness in an ordinary sense. Again, it is subject to a so-called threshold requirement where only unfair treatment that rises to an international level can be seen as breaching the treaty. So continuing with CETA, here we have language with respect to ongoing review of the content of the obligation. So you recall that in this subsection F contemplates possible further elements. And so then in the next provision, we see how these further elements might be introduced. So here under this CETA provision, the parties shall regularly review the content of fair and equitable treatment, and the Committee on Services and Investment may develop recommendations in this regard and submit them to the CETA Joint Committee for decision. Now, on this point, and you will recall that one of the areas that UNIDROIT working, or excuse me, that UNCITRAL Working Group 3 is looking at is they are looking at interpretation by governments, interpretation of treaties by governments. And one policy option when thinking about different ways that governments can interpret treaties is through the use of so-called joint interpretation mechanisms. And so here we see under the CETA agreement, one version of a joint interpretation mechanism where the CETA has a joint committee, and then you have this subcommittee on services and investment, which can develop recommendations for the overall CETA joint committee. And then the committee can then issue clarifications, issue interpretations of particular treaty provisions, including the CETA provision on fair and equitable treatment. On this point, I would mention the NAFTA experience. I'm sure many of you are familiar with the NAFTA Free Trade Commission interpretation. And that so-called NAFTA FTC interpretation, that interpretation was issued in 2001. So at this point, more than 20 years ago, when the interpretation, and the interpretation was on the minimum standard of treatment obligation, responding to a few of the early NAFTA decisions, which applied very expansive understandings of the minimum standard of treatment obligation. So the joint interpretation was a response to a few of those early NAFTA decisions. And when the NAFTA Free Trade Commission issued their joint interpretation, it was controversial. There was a fair amount of controversy. And the controversy surrounded the issue of whether the interpretation should be seen as a clarification, an interpretation of the treaty, or as an amendment of the treaty. That there were some who argued that functionally the interpretation was operating as an amendment of the treaty, which of course would need to be subject to procedures for amendments. And so with respect to this CETA provision, I think here again, that's an issue that we certainly should keep an eye on, that if we see the CETA Committee on Services and Investment, if they do become quite active with different kinds of recommendations, we do need to keep an eye on this distinction between clarifications, interpretations on the one hand, and what could be seen as, in effect, amendments of the treaty on the other. And so for that reason, when I see in the previous provision that this idea that there might be further elements developed, that does raise question about to what extent should further elements be seen as clarifications, or should they be seen as amendments of the treaty. And having mentioned the FTC interpretation, I would just note that we hear so much today in the investment arbitration area about the so-called rebalancing of the regime. And really going back to 2001, we can see with that NAFTA FTC interpretation that those were some of the earliest steps at an attempt to rebalance in terms of providing greater regulatory space for governments, and in terms of rebalancing sovereignty concerns with protection of investors. Following that 2001 interpretation, we had the US developing its 2004 model bilateral investment treaty. So we think about the years involved, 2001, 2004. I mean, this is a long time ago. And so this process of rebalancing has been playing out at this point, for 2 decades with respect to investment arbitration. So I think it's an important point to keep in mind that as we see ongoing discussion about rebalancing, we see emphasis on sustainability, we see emphasis on the need to consider climate, to consider the climate emergency as we recalibrate investment treaties, that this need for recalibration, that this need for rebalancing has been occurring again for a few decades. But what we see over time, especially with issues specifically concerning sustainability, specifically concerning climate, we do see that need for recalibration is constantly being updated as governments must respond to new challenges that come to the fore, as we've seen in particular with sustainability and with climate. Another point I would make on fair and equitable treatment is the role of legitimate expectations. And this is an area where there has been quite a bit of uncertainty in the jurisprudence in terms of what exactly is the relationship between what is known as the frustration of legitimate expectations and the violation of the fair and equitable treatment provision. Part of the uncertainty concerning legitimate expectations involves what might create legitimate expectations. I think most people would agree that if the government has made certain promises, what are known often as specific assurances, if the government has made specific assurances, I think many people would agree that yes, that can create so-called legitimate expectations. I think where a point that's more controversial is whether a relatively stable regulatory regime, if you have a regulatory regime that has basically been unchanged for a significant amount of time, under what circumstances might a stable regulatory regime create legitimate expectations such that a dramatic change in that regulatory regime could be seen as frustrating legitimate expectations? And then a related question would be, does the frustration of legitimate expectations actually violate a fair and equitable treatment obligation under an investment treaty? And so this is where there has been a lot of disagreement, and we have a lot of recent treaty practice where governments are attempting to address, in particular in their treaties, the issue of legitimate expectations. And so here we see in the CETA agreement that when applying fair and equitable treatment, the tribunal may take into account, so this is discretionary, whether a party made a specific representation to an investor to induce a covered investment that created a legitimate expectation and upon which the investor relied in deciding to make or maintain the covered investment, but that the party subsequently frustrated. So I think in this provision, the governments are clarifying a few different points. One point is that legitimate expectations can arise from specific representations by a government. And I think what this implies is that legitimate expectations most likely will not arise from the mere stability of a regulatory regime, that a regulatory regime is not speaking to an investor the way a government official speaks to an investor. And so in that sense, under this treaty, it looks like that for an investor to argue legitimate expectations, they must be able to point to some specific representation that was made by some kind of government official. And then the next point would be that the frustration of legitimate expectations on its own, without more, does not violate fair and equitable treatment. Rather, it would be one relevant factor to be taken into account when determining whether there has been a violation of fair and equitable treatment. So again, this provision is anticipating a kind of claim that has been made in many cases where an investor argues that the mere frustration of legitimate expectations without more violates fair and equitable treatment. A few other clarifications in CETA on fair and equitable treatment that I would note. So one is, and this is tracking language from the NAFTA FTC interpretation, that a breach of another provision of this agreement or of a separate international agreement does not establish a breach of the CETA fair and equitable treatment provision. So this, again, tracks the FTC interpretation, the NAFTA FTC interpretation, and the NAFTA was responding to, as I mentioned, one early NAFTA decision that in effect found that the violation of one particular NAFTA Chapter 11 obligation pretty much established the violation of the NAFTA minimum standard of treatment obligation. And so this is responding to that kind of a finding, which again is tracking the NAFTA FTC interpretation. This next clarification that we see is not in the NAFTA interpretation, but it's a helpful clarification that often does arise in investment disputes, and that is that the mere breach of domestic law does not, without more, establish a breach of fair and equitable treatment. And this again is reinforcing the point that there is a threshold requirement for fair and equitable treatment, that we are operating on the international level. And so the mere breach of domestic law, that is certainly a relevant fact to be considered. But we consider that relevant fact in the same way that we might consider the frustration of legitimate expectations as a relevant fact, that relevant fact, without more, does not establish a violation of the international legal obligation of fair and equitable treatment. A few other approaches to fair and equitable treatment in terms of policy options. A different policy option would be to drop fair and equitable treatment from the investor-state dispute settlement procedure. An example of this is in the recent US, Mexico, Canada free trade agreement. Under this agreement, Canada opted out entirely from investor-state arbitration. So Canada did not agree to any investor-state dispute settlement mechanism under the treaty. So what you have is the United States and Mexico agreed to a bilateral ISDS procedure. But in terms of the claims that can be submitted to investment arbitration under the USMCA, the US and Mexico agreed to a subset of obligations. So even though the investment chapter of the agreement includes the minimum standard of treatment, that obligation was excluded from the dispute settlement procedure under the USMCA. So you can see that under this provision, that for purposes of ISDS, for purposes of investor-state arbitration, that the only claims that can be brought are alleged violations of national treatment, most favored nation treatment. And notice that with respect to national treatment and most favored nation, that the parties have excluded claims that concern the establishment or acquisition of an investment. And so these are known as so-called pre-establishment obligations, that most investment treaties cover what's known as the post-establishment period, when the investment is already established in the host state. Some treaties, including the USMCA, cover the so-called pre-establishment period. So when an investor is seeking to make an investment, that would be the pre-establishment period. But we see that under this provision, that pre-establishment period is excluded from the investor state dispute settlement provision. And then we see that an investor can also bring an expropriation claim. But again, for purposes of ISDS, this provision excludes indirect expropriation. So you can bring a claim for direct expropriation. You cannot bring a claim for indirect expropriation. And when I turn to the expropriation provision, I'll share a few more thoughts again on this distinction between direct and indirect. So notice what is missing from A and B: A, national treatment, MFN; B, expropriation. So you see no mention of the minimum standard of treatment. So again, the minimum standard has been excluded from the scope of the ISDS procedure under the US MCA. So next, I'll be turning to expropriation. I think now might be a good time to pause, in part just so that I can have a bit of water. But while we pause, I'd be happy to take any questions that you might have in terms of the material that I've covered so far. So no questions at this point on any of the material that I've covered?
Professor, if I may.
Yes, please.
But before my turn, I think there's a student, Donna Regina. Maybe Donna can ask you a question first, then I follow you later.
Sure. Yes, please.
Yes, Donna.
Thank you so much for the opportunities, Pak Gary and Mr. Feldman. If I may, I would like to ask regarding one of the elements of the fair and equitable treatment, the abusive treatment of investors, such as coercion, duress, and harassment. To the best of my knowledge, the physical or abusive treatment of investor that might cause a direct harm is fall within the scope of the full protection and security obligation. So by this, my question is, does the full protection and security obligation is one part of the fair and equitable treatment standard, or is it different? Thank you so much.
Okay, thank you for the question. And so first, I would say that there are many different views on these relationships between the minimum standard, fair and equitable treatment, full protection and security. My understanding, and this is what you will see in many treaties, is that the minimum standard is the blanket obligation. And so then the question becomes, under the minimum standard, what obligations are to be included within the minimum standard. So I would include under the minimum standard fair and equitable treatment, full protection and security, both within the minimum standard. Now notice that in CETA, when we have that list in the CETA treaty, that list is clarifying fair and equitable treatment, right? And it's on that list that we see abusive treatment, right? So I think what I can say is that it is an unsettled issue in terms of if you did want to argue or if you were defending a claim that involved physically abusive treatment, whether that best fits simply within the minimum standard or best fits specifically within fair and equitable treatment or within full protection and security. Right. I mean, if you start researching the issue, you're going to find different views on the issue. And again, even in the treaty practice. And an additional complicating layer that I would add is some treaties will include treaty covers economic, right? So if we have a situation of physical abuse, then a government can argue that a claim of physical abuse is beyond the scope of economic rights. But I think that raises the question for treaties that include and do not clarify that they're limited to economic rights, and physical abuse is now in a gray area. So those are my thoughts, but a great question. Okay, thank you. Any other questions on anything I've covered so far?
Professor.
Sure.
First of all, thank you for the opportunity, and thank you also for come again to Faculty of Law, Universitas Padjadjaran. It is about the I think that there is a clear big taken place for reforming the old investment treaties, according to your lecture, with the addition of public policy exception, reform on MFN, national treatment, and fair and equitable treatment. The existing treaties, as far as I understand that the modernization or the effort to modernize the creations, for example, on NAFTA FTC interpretations, but how effective is this? How about the amendments of the old investment treaties? Is it possible? Has there any amendments taken place yet? Or even maybe the substantive reform for the old investment treaty is not that important to be amended in a traditional way by, going to negotiation again. Thank you, Professor. I think that's my question.
Sure. Thank you, Gary. And let me just say again, I enjoyed the session last year so much. And it's really just, it's an honor to be able to return again this year and to have, I mean, especially to have this amount of time for discussion. That these are rare opportunities, right? That you think about a typical panel, you might have 10 minutes, right? So to be able to really go kind of deep on these issues is an amazing opportunity. And on your point, I think if you look at initiatives, in particular like the UNCTAD initiative, that UNCTAD is certainly thinking about those old treaties and wanting to help facilitate the transition away from the old treaties, because the old treaties raise a lot of uncertainty. I mean, an issue that has been important for years has been, let's say you're a government, you have your newer treaties, you have your older treaties, a claim is brought under one of the older treaties. To what extent can the government argue that yes, that's the language in the older treaty, but our understanding of those obligations has been clarified through later treaty practice. And so we think that our later treaty practice should be helpful for interpreting those older obligations. I mean, that is certainly an argument that a government can make, but different tribunals are going to respond in different ways to that kind of an argument. So I think a different alternative that should be considered would be moving away, to the extent possible, moving away from the older agreements entirely. And I mean, of course, there are different ways to accomplish that. And you could certainly do it on a bilateral basis, but you might be able to do it with more than one treaty partner at a time. But I think that to the extent that those older treaties are still in force, it really creates a lot of uncertainty. And so I think it's in the interest of governments to be very active in terms of updating their treaties. And again, there may be options for updating that might involve some burden, but would not involve the very heavy burden of having to start from scratch bilaterally with a number of governments, that there should be more efficient ways of
yeah, Professor, I think, yeah, so amendment, I think it's not the option. It's maybe additional burden to, negotiate. But I think just long create a new trend. I think it's yeah, maybe it's the best for the reforming, if I'm not mistaken about the answer. And I think there's also a trend about a more comprehensive investment treaties like RCEP and TPP, which also incorporates this, this movement by Uncitra Unstad or any other interpretations out there. I think I don't know whether it's true or not, because the modern investment treaties is more comprehensive like RCEP and TPP, and the complexities, and they have also have to face multifaceted issues, not only just investment, but also, for example, sustainable development, climate change, etc. That makes the comprehensive investment treaties is in a place that they have to go into the movement. I think that's my view. Thank you, Professor, for the clarification. Professor? Professor Feldman, can you hear me? Adiana, can you hear me, Adiana?
Yes.
I think we lost Professor Feldman. I think he's freezing, right? I think let's wait for Professor Feldman to have better connection.
Oh, wait, Gary?
Yeah, Professor,
Okay.
I think you're freezing for the last minutes.
Yeah, but I think, can you hear me okay now?
Yeah, we can hear you clearly now.
Okay, so, sorry about that.
No worries.
Yeah, so just making the point about the investment obligations falling within free trade agreements, and that certainly does complicate the issue. And I would just add on that point that especially with regional value chains, with global value chains, that we see a lot of overlap between trade activities and investment activities. And so this is another area where you can have challenging questions in terms of if you have intertwined trade and investment activities, to what extent should those intertwined activities be covered by the investment obligations, right? So that's another, I think, consequence of this trade and investment that does further this issue.
Professor.
Thanks again. So any other questions before I go back to the presentation?
To the students, I think we have not only the student from Universitas Padjadjaran, Professor, from the attendant list, I can see that we have also international students from another university joining us today. I think if you have any question, please do not hesitate to raise your hand, or you can type your question in the chat box. Rizka, the MC for today's activities, will read the question for Professor Feldman, I believe. So yeah, please do not hesitate to ask questions. And also for the student from Universitas Padjadjaran, if you have any question, please ask directly to Professor Feldman, or you can type your questions. I think this is a very, very good opportunity, very rare opportunity we have in such an international prominent professor right here. So we have to, ask as many as questions to Professor Feldman, in order to have some direct clarifications. Please. If you have any.
Not yet, Pak Giri.
I'll just share the PowerPoint again and move on to expropriation. As I mentioned with expropriation, one trend that we see in recent practice is the distinction between direct and indirect expropriation. So indirect expropriation, also sometimes referred to as regulatory expropriation. So again, when regulations render the value of an investment worthless, but there's no actual transfer of title. So we can see that one policy approach that we see in the Brazil-India Treaty is to simply exclude indirect expropriation from the treaty. So the treaty covers direct expropriation, but does not cover indirect expropriation. And you see in this provision 6.3 that the drafters make absolutely clear that indirect expropriation is not covered. Another interesting clarification, this is in the RCEP agreement. The RCEP has an entire annex on expropriation, clarifying the expropriation obligation. And one clarification that we have in RCEP is that expropriation is limited to property rights and property interests in covered investments. And so this is a response to many arguments that have been made by claimants where they might argue something to the effect that perhaps they had a certain market share in a jurisdiction and a regulation has taken away their market share. maybe they've lost all of their market share. And so by clarifying that the obligation is limited to property rights and property interests, that anticipates this kind of argument that, well, I used to have a certain level of profitability, I no longer do, or I used to have a certain level of market share, I no longer do. So this kind of provision, again, anticipates that you must be able to show that what was expropriated was a property right or a property interest. An investor does not have a property right or property interest in a certain level of market share. Here we have additional clarification on indirect expropriation. These factors, I mentioned briefly earlier that what's known as treaty propagation, where provisions in one treaty will then be picked up, perhaps adapted in other treaties. And these factors, these A and C factors that you see here, this is an example of propagation. These are factors that in slightly different form are known as the so-called Penn factor. This is a reference to a US Supreme Court case that was called Penn Central versus New York City. This was a domestic case, and the claim was not, rather it was under US domestic law as a takings claim, alleging a violation of the Fifth Amendment of the US Constitution, which protects against takings without compensation. Of taking is treaty practice, incorporated factors from this Penn Central decision that were guiding the Supreme Court's analysis of what under US domestic law is known as a regulatory taking. And so the US incorporated these factors into their treaties, and now the factors have found their way into many other treaties, including the RCEP treaty. So you see that the first factor A is the economic impact of the government action. So has the value of the investment been reduced all the way to zero? B, whether there was breach of the government, some written commitment. This is a different version of what reasonable expectation. The character of the government action, including its objective and context. And you can see in the footnote that Korea has offered interesting proportionality analysis on this point, that if it appears that one particular investor has really suffered the brunt of some regulation, that also can be relevant to the takings analysis. So again, these factors originally inspired by a domestic US Supreme Court decision, but now have been elevated to the level of international law through treaty practice, including practice by the RCEP parties. This next clarification from RCEP, this kind of language appears in many investment treaties, clarifying that non-discriminatory regulatory actions by a party that are designed and applied to achieve legitimate public welfare objectives. And then we have examples such as the protection of public health, safety, public morals, the environment, real estate price stabilization. Those kinds of regulatory actions are not expropriatory. So notice that under this exception, that if we have this kind of regulatory action that is aimed at achieving legitimate public welfare objectives, that action will not be expropriatory. It will not lead to an expropriation, regardless of the economic harm that is suffered. So as I read this kind of exception, so long as a regulatory action is legitimate, that even if the value of the investment went to zero, that government act would still not be seen as expropriatory. And if the government act is not expropriatory, then there has been no violation of the expropriation provision. I'll have some related thoughts on this point when I turn to general exceptions and when I turn to the recent claim against Colombia that has received a lot of attention, again, because of the way that the majority in the case applied a general exception involving the environment. So I think it's related to this kind of exception that I'll address in a few minutes. I would turn now to investor obligations. This is certainly a recent trend that, and first a few thoughts on what we mean by a balanced investment treaty. That there are certainly some who make the argument that without investor obligations, without obligations that run to both governments and investors, that an investment treaty cannot be balanced. And I do not agree with that argument in the abstract. And the reason why is that if a treaty is according protections to both sides' investors, so long as the protections are running to both sides, I think the treaty can be seen as balanced. I think where the treaty can become imbalanced is when the obligations are, the protections are really only being enjoyed by one side, and the other side, in terms of their investors are really not receiving much in the way of protection. In that kind of a situation, then I think there really is an imbalance issue that needs to be addressed. And one way to address that imbalance issue is by incorporating obligations that run to investors. But this treaty practice is new. It is in many respects creative. But when we have creative treaty practice, we also have uncertainty. And so I'll just briefly highlight a few uncertainties that I see with this recent treaty practice involving investor obligations. So here's one example. Brazil, India, just an obligation. Notice the use of shall, that when you see that word shall, okay, this is a binding obligation. This is not aspirational, this is binding. And so here we see a binding anti-corruption obligation in the Brazil-India treaty. Then we have a binding transparency obligation in the Brazil-India treaty. And on transparency, I think this is an interesting use of an investment treaty to use the treaty as one way to advance transparency within the host state, that you see the obligation requires the investor to provide perhaps more information than would be required under domestic law. Now, one overall issue that I see with investor obligations in these treaties is I think we need to know more in each jurisdiction in terms of how much communication is there between the ministry that is negotiating treaties and then the domestic legal system, right? The domestic court system, the domestic administrative system. Because in my experience, something that I've just observed frequently is that in general, that the ministry working on international law, there needs to be more communication between the ministry that's working on international law issues and all of the domestic officials, right? They need to be in closer coordination. And so one question that I have with a provision like this is, if there are greater transparency requirements that are being imposed at the international level, to what extent are the people at the working level domestically, to what extent are they aware of these additional international requirements? And so that's just an issue that I would flag. Here we have the Morocco-Nigeria bit, again on anti-corruption, again using the word shall, so a binding commitment. And then in the same treaty, we have the clarification that a breach of this article by an investor, this anti-corruption article, is deemed to constitute a breach of the domestic law of the host state concerning the establishment and operation of an investment. So here again, we see that it will be very important under this treaty for there to be close coordination between the people working on the international level and the people working at the domestic law level to make sure that everyone is on the same page, shares the same understanding about how this provision should work in practice. And I think that kind of an issue is in even greater relief when we see this Article 20, liability under domestic law, that an investor shall be subject to civil actions for liability in their home state for acts and decisions that cause harm in the host state. So when I see this kind of a provision, what comes to mind is that if we're in the courts of the home state and a domestic judge is presented with this treaty provision, it's not clear to me how the domestic judge, especially on questions of jurisdiction, will a domestic judge simply see Article 20 and will that be enough to persuade the domestic judge that, okay, I have jurisdiction because Article 20 says so. Article 20 of this treaty says so. So again, it's another complicating factor when we are incorporating investor obligations into investment treaties. I'll now turn to just a few thoughts on a few different exceptions, and then we will have time for discussion. The first exception I would highlight is what's known as a prudential measures exception. In terms of services, international obligations with respect to services, this type of prudential measures exception has been very common. It is sometimes used in investment treaties. We see the exception being used in the Brazil-India treaty. And I think that provision C really captures the heart of a prudential measures exception, that when a government is acting to ensure the integrity and stability of their financial system, that a prudential measures exception will accord the government a great deal of regulatory space to be able to ensure the integrity and stability of its financial system. And I think that use of this kind of an exception in a way is more tailored to financial regulation. I think without this kind of exception, what you often will see is governments resorting to a so-called necessity exception or an essential security exception. A necessity exception, essential security exception, these apply very broadly, but especially the necessity exception under customary law can be very difficult to establish, as Argentina experienced in many of its cases arising out of the 2001 financial crisis, where Argentina was relying on essential security and necessity exceptions. I think that the availability of a prudential measures exception can be quite helpful for governments that experience something like what Argentina experienced in the early 21st century, or if you look at the 2008 financial crisis, responses to the 2008 financial crisis, if there's an interest in providing a lot of regulatory space with respect to financial regulation, then I think a prudential measures exception can be a good policy option. Another exception that I would just briefly mention is we see more and more attention on the relationship between investment obligations and intellectual property obligations. And of course, Gary raised the issue about investment obligations within free trade agreements. And of course, free trade agreements normally will include an intellectual property chapter. So here we see provisions addressing some of the relationship between investment obligations and intellectual property obligations. I would note that there have been a number of cases where claimants have successfully argued that different intellectual property rights do qualify as covered investments. Philip Morris against Uruguay, of course, Philip Morris lost that case, but that was a trademark that was protected under the investment treaty. More recently, you have Eli Lilly against Canada, where Eli Lilly brought an investment claim involving the invalidation of 2 patents by the Canadian courts. Now, Eli Lilly lost that case, but the idea of patents qualifying as a protected investment, that was established by the claimant. So we do see the need to think in particular about this relationship between intellectual property rights and investment rights and government regulatory space. And so this TPP exception is one provision that addresses that relationship. And finally, I would turn to general exceptions. Here, this is a recent trend of the general exceptions really coming from trade law practice. Now in investment law, we have parties that are basically importing a trade law kind of general exception into their investment treaties. But of course, creating some uncertainty in terms of how tribunals, investment tribunals will actually apply these general exceptions. And so what we had in the Eco Oro against Colombia case was, and that involved the Canada-Colombia Free Trade Agreement. And there was language in that agreement that was very similar to the general exception language that you see in this Brazil-India agreement. And in particular, if you look at category D, to measures necessary to protect and conserve the environment, including all living and non-living natural resources, the tribunal in Eco Oro, that they were dealing with very similar language. And the case involved, it was kind of a classic dispute between an environmental regulation that interfered with an investor's mining rights. And so Colombia, as the respondent, was arguing that the regulatory space that was provided by this kind of a general exception protected it against the claimant's investment claim. And the majority, reading, again, language very similar to this general exception language, interpreted the provision as being permissive. That was the term that the majority used, that the exception is permissive in the sense that it's allowing the host state to regulate in this way. But then the majority went on to find that although the government, in effect, has permission to regulate in this way, that the government is still liable to compensate, notwithstanding the existence of the exception. Now, I will say that there has been a very strong response to that decision. And I would underscore that individual investment arbitration decisions are not binding precedent. So this decision in Eco Oro, it is not binding on any other tribunal. Other tribunals are free to ignore the decision. But there was concern, especially because there has been so much recent treaty practice in the area of exceptions. It has raised real concerns about how tribunals going forward might apply different exceptions, and in particular, whether tribunals might also refer to exceptions as being permissive, as permitting certain forms of regulation, but as not exempting the government from liability. And one response I have on that point in terms of an exception being permissive is a government does not need permission from a treaty to be able to regulate, right? That the government of Colombia did not need a general exception in a free trade agreement to regulate the environment. That as a sovereign, the government of Colombia has the right to regulate the environment. So I'm certainly not alone in this view that the idea that this kind of an exception is merely permissive, I think is really missing a core point, that governments do not need to turn to a free trade agreement to obtain permission to regulate. The government can regulate, and then the question is, when, if ever, is the government liable for harm that its regulation has caused? And as I read this kind of general exception, and again, the language was very similar in the Colombia case, that if a government is acting on a non-discriminatory basis, and if the measures are generally applicable, and the measures are necessary to protect and conserve the environment, then under this kind of exception, the host state should not be liable. Now, of course, you can have questions of good faith, whether a government has acted in good faith, whether a government has discriminated, whether the measures were actually necessary. But so long as a government is able to satisfy all of those elements, then as I read this kind of provision, the government should not be liable for compensation. So with that, I will pause and stop sharing. And I think now we have time for open discussion. I've covered a lot. So I certainly look forward to questions, comments, and to our discussion.
I think we have Adiana, Professor. Adiana want to ask question, and also Deslina Maharani. Maybe we can start with Adiana. Is it okay, Professor Feldman?
Sure.
Yeah. Adiana, please go ahead.
Thank you very much for the opportunity. I would like to ask questions, Mr. Mark. It is just out of my curiosity. From your previous explanations relating to this reform of investment treaty substantive obligations, I took an example, the substantive obligations on the minimum standard, which the modern treaty already put more detailed elements that could constitute a breach of minimum standard. And some of those elements, as far as my past knowledge, are new for me, being included in the FAT elements. for instance, the abusive treatment to the investors. Thus, whether this reform of investment treaty substantive obligations came from the development of the foreign direct investment general practices, or it is actually already exists way before this reform, and now it is being clarified through the treaty. Also, whether it could be applicable to the old model of the international investment treaty. Thank you very much, Mark.
Okay, thank you for that question. So, as I mentioned, you can go back to the Near versus Mexico decision, U.S.-Mexico Claims Commission. That's a decision from the 1920s. The Near decision is about 100 years old. And so 100 years ago, the minimum standard of treatment had this element concerning abuse of natural persons, right? So that is nothing new. I think it's interesting that in CETA that the drafters chose to affirmatively include that on their list. I mean, that was an interesting policy choice. And I think for governments just need to be really aware that if they do want to make sure that their investment treaties are only covering economic rights, then it's a good idea to include language like that in the treaty. Because again, the minimum standard traditionally understood will have this physical component. Is that
very much, Mark? Yes, it is. It is answered my question. But actually, it is already exists way before this present time, and it is just being clarified through the treaty. Is that true?
Exactly. And then I would just emphasize that policymakers are, it's customary law, but policymakers are free to depart from that customary law, and they're free to narrow the obligation as they wish.
Understood. Thank you very much, Mark.
Thank you.
All right, maybe we can move to Desliana Maharani.
Okay, thank you for the opportunity, Pak Gary, and thank you for our Professor Mark Feldman. I want to ask in the beginning, in the slide of UNCITRAL Working Group 3, in the concrete reform of element, you mentioned about the shareholder claims. I want to ask about the shareholder claims. In a lot of literature, it is said that the enterprise and the shareholder are two entities with the same identity, which implies they are the same parties. But however, there is certain cases such as CMA and Lauder, which the shareholder had their own right to claim separately from their enterprises. Thus, I want to ask about how to determine the difference between shareholders' rights, shareholders' right that is separate from the enterprise, and the shareholder right to claim, which are constituted as the same parties. The BIT is not regulate this yet in the BIT, whether it should refer to the economic approach, or was there any other approach that could be used to distinguish about the shareholder claims? Thank you.
Okay, thank you. So as we think about shareholder claims, so-called reflective loss claims, I think what we can say is that investment arbitration law, when you compare it to domestic law, when you compare it to the Barcelona traction ICJ decision, that international investment law has really gone in a different direction. That under domestic law, under Barcelona traction, when the harm that is suffered by a corporation, it normally is only the corporation that has standing to seek relief for that harm. And I mean, some examples that the Barcelona traction decision discusses in terms of what kinds of claims can shareholders bring, that the ways that shareholders are directly impacted by government decisions is maybe they had a right to collect dividends, or maybe they had a right to participate in meetings or to vote in meetings, right? That there are rights that are directly held by shareholders. But if the corporation loses value, under domestic law, under customary international law, a shareholder is not going to be able to claim, right, for that loss in value. But what we've seen with many investment law decisions is tribunals have allowed those kinds of claims to go forward. And I think this is part of the reason why UNCITRAL that's one of the issues that UNCITRAL is focused on. And I mentioned how the UNCITRAL reform efforts are basically procedural, but this is one procedural reform effort that certainly does have substantive consequences, real substantive consequences. And in the treaty itself, policymakers can directly address this kind of issue. I mean, an example I would give is just, if you look at the NAFTA treaty, NAFTA has two articles. One article 1116, another article is 1117. And 1117 expressly contemplates claims brought by shareholders on behalf of a corporation. And I think that for that kind of treaty practice, for policymakers to provide more guidance about under what conditions are they okay with shareholders bringing claims on behalf of corporations. And again, I think NAFTA Article 1117 is a nice example on that point.
Okay, sir, I think it's more than enough to answer my question. Thank you.
Okay, thank you.
All right. Is there any more questions for Professor Feldman? Please raise your hand, or you can also chat your question in the chat box. Let's see. So, Professor, while we are waiting for more questions from the students, maybe I have one following up questions. It's not following up question, actually. It is a different question. From your presentations, it is very interesting to know that Brazil and India investment and facilitation treaty has this particular clause on anti-corruption. I think it is very common for at the level of government to government having this kind of rules. You know, I'm talking about the invalidity of treaty under VCLT, but that's on the level of governments, right? It is very interesting that that now in the treaty itself, they have obligation on anti-corruption, and it is very interesting also to know that the investor cannot take action of corruptions both prior and after the investment itself. The question is, what will happen if in fact the investors has this case of corruptions involving government official, etc. Is there any implication also to the existence of the treaty, or what will be the consequence of this action? Since you know, I'm trying to search for the investment treaty, but I cannot find the Brazil and India investment and facilitation treaty. And also the second question is about the Morocco-Nigeria treaty, where they have regulation also on the jurisdictions. I'm just thinking, is it really need to regulate the jurisdiction about civil liability in the investments? Since with or without the existence of this clause, I think the government has opportunity to establish jurisdiction using classical jurisdictional principle, territorial jurisdictions, personal jurisdiction, etc. Is it really important to have this clause in a modern investment treaty? Thank you very much.
Thanks, Gary. Well, they're both good questions, and I think your questions are getting at just a lot of the uncertainty that this treaty practice is raising, right? And I think that the uncertainty, there's kind of one core issue, I think, in play here, which is the relationship between international law and domestic law. That, I mean, as you say, the domestic law presumably is going to have provisions governing anti-corruption, provisions governing when an investment has been made in compliance with law, right? So the domestic law presumably will address those issues. But now in the treaty, now we have the treaty addressing those same issues, but in ways obviously that are not identical to how the domestic law addresses the issues, right? So think of anti-corruption. I mean, I'm sure in the host state there will be rules on anti-corruption, but those rules are probably not identical to the language in the treaty. So going back to your question, what happens if you violate the rule as stated in the treaty, but you did not violate the rule under domestic law? What are the domestic law consequences? What are the international consequences in terms of your claim going forward, right? So I think that with these investor obligations, there has to be more thought given to the relationship between what's happening on the international level and what's happening on the domestic level. I mean, I think one way that it's clearly helpful is by making absolutely clear that if your investment is not legal, if you've engaged in corruption, at a minimum, that should preclude your investment claim. But even there, again, there are questions of if you violated the international rule, but not the domestic rule, right? Does that stop your claim? Right, so I think it's good for governments to be thinking about these investor obligations, but I do think that in practice, I think they're going to raise a lot of questions in practice.
I think I have comments on that, Professor, if it's possible. So I think we will have to go through the discussions of the position of international law within domestic legal system, right? If there's a violation, clear violation on an international level in the treaty itself, but there's no violation under national law, we should look at, we go through the debate between monism, dualism, and the way in between, there's a lot of theories on that. And I think that will be very different if we compare the practices between states, because again, if we want to look at the positions, we have to go through each state constitutions. What will be the positions of investment treaty? Can the judge of national court do incorporate the investment treaty, treat the investment treaty as its national law within domestic legal system? I think that's my thought. And also, how about the jurisdiction, professors? Is there do we really need? Is it really important to have jurisdictional rules on civil liability involving investors.
Right. That one provision that I highlighted about civil liability, I mentioned, I have to think that domestic courts are normally very cautious about questions of jurisdiction. And at a minimum, looking to a treaty provision, the judge most likely is going to be outside their comfort zone, right? In terms of they're looking for jurisdiction. This is just not a source of law that they are used to looking at. And so I think that was part of the point that I was highlighting, is what I anticipate is for domestic judges that are presented with that kind of a provision, at a minimum, I would expect them to be very cautious about giving that provision a lot of weight when deciding whether or not they have jurisdiction. Yeah.
Yeah. Thank you, Professor, for the clarifications. I think I got the answers.
Okay,
right.
Very good. Were there other, we still have some time, were there other questions?
We have Darian Amarta, Professor. Darian, please.
Yes, please.
Hello, am I audible?
Clearly?
Yes.
Okay, thank you. Professor Mark Feldman, you previously explained that in recent practice and recent treaties that national treatments are limited to competitor in like circumstances. My question is, if a state creates, let's say, a regulation which targets only the foreign companies, however, there are no domestic investors in that particular circumstance, would national treatment then still be available for protection of the investor, or should the investor simply seek for, say, a fair and equal treatment under those circumstances?
Right. So your question really goes to, it illustrates how the like circumstances element can be so challenging to apply. So, I mean, I would mention a few different cases. So one, there was a set of 3 claims brought against Mexico involving high fructose corn syrup. And there, Mexico was according different treatment to producers that were, for sweeteners, they were using cane sugar. The producers using cane sugar were in Mexico. The producers using so-called high fructose corn syrup were in the US. And the less favorable treatment was being accorded to the US users of high fructose corn syrup. And so then a key like circumstances question becomes, did the host state have legitimate policy reasons for treating producers using high fructose corn syrup differently from producers using cane sugar? Another case I would mention is Methanex against the US, where the state of California was according different treatment to one gasoline additive that used methanol versus another gasoline additive that used ethanol. And so again, a key question becomes, does California have a legitimate policy reason for according different treatment to ethanol-based products versus methanol-based products? So the question you ask, I mean, these questions come up all the time, and the analysis will always revolve around, is the government able to make some kind of showing that they had legitimate policy reasons for according the different treatment, if that helps.
Thank you, Professor. That answers the question.
Okay, great, thank you.
So is there any more questions? Is there any more question from the students, please? raise your hand. No more questions? You can also type your question in the chat box if you don't want to ask question directly. All right. I think, Professor, we have no more question, I believe, about the lecture. Or shall we keep waiting, or we can just go to the conclusions?
Okay, if there are no more questions, I guess just a couple final thoughts.
All right.
Would just, as I mentioned, this rebalancing process really started 20 years ago, right? So we've been working on rebalancing for 20 years. And now we have these additional layers of complication involving sustainability, involving climate. And so the issues are becoming more challenging. But I do think that the overall orientation is very different from where the orientation was 20 years ago. And I think that today it is simply understood that governments must have sufficient regulatory space. And I think that's part of the reason why the recent Columbia decision has received such strong reactions. So I would suggest overall that as we think about recalibrating, as we think about rebalancing, that this is a process that continues, has been continuing for the last 2 decades, and will continue into the future. And it will be really interesting to see the role that institutions are playing, in particular UNCITRAL and UNCTAD, and then the role that governments are playing in their own treaty practice, and the extent to which that the institutions might be able to support the governments in those reform efforts. And I will say again that Professor Preeta and Gary, I appreciate so much having the opportunity to meet with you again this year, and I look forward to meeting with you again in a few weeks to talk about some different issues. But really, it's an extraordinary opportunity to be able to have this kind of time to really go kind of deep on these important issues. And so I just greatly appreciate it, and thank you again.
Thank you, Professor. As I said, it is an honor for us. Thank you very much for coming to Universitas Padjadjaran and also share a very, very important topic today. I think this is very new for us, for me especially, because now I know that there is a green investment treaty, for example. So the topic of climate change is not spreading to the limitation of, let's say, transportations treaty or industrial related treaty, but also in the investment, in the level of investments. And also it is good to know that the movement towards more sustainable Earth and also more a greener Earth to combat climate change also caused a challenge to the old established rules of trade and investment, MFN, etc. I think this is very important highlight for students, and I think this lecture have to be complete, have to make the knowledge of the student complete. They learn the basic from the lectures at the Faculty of Law, University, and they also learn the development, the current development from you. I think I hope this is not the last time, Professor, you are teaching us. We are looking forward to see you again on another topic of lectures, of course, with a more broad audience, maybe different classes. And we have also here Ibu Helita Novianti. Ibu Helita, do you have any thoughts, or maybe you want to say something to Professor Feldman, please? Ibu Helita is one of the lecturer in the investment law course, alongside with Ibu Preeta Amalia.
Yeah, thank you, Professor. It's a very comprehensive study. Thank you for joining with us in this class. Yeah.
Oh, thank you. Thank you again.
Thank you again. So I think we have reached the end of our session, professors. We have go through a lot of new materials, new knowledge, of course, for students. It is, again, it is a very rare opportunity. We learn directly from the international professors. So for that, we are very, very grateful. And having said that, I will give the floor back to the Master of Ceremony. I'm sorry to hijack your session, by the way. Rizka, the floor is yours. The screen is yours, actually. It's not the floor.
Okay, Mr. Gary, no problem. Thank you for Mr. Gary for the explanation, and I thank you to Professor Mark for the lecture you have presented. So we hope that the knowledge you have shared will be beneficial for all of us, and I hope our discussion has been fruitful and insightful for all of us. Ladies and gentlemen, we have come to the conclusion of this webinar. So on behalf of the host, I would like to extend our greatest gratitude and appreciation to our speaker and all participants for being able to participate in this webinar. We would also like to apologize for the mistakes we have made during this webinar. As your Master of Ceremony, I, Rizka Olivia Zahra, would like to say thank you very much for being present today. We wish you a pleasant great day ahead. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi Santi Om, Namo Buddhaya, Salam Kebajikan. Thank you.
Okay, thanks everyone.
Thank you, Professor.
Thank you, Professor.
Thank you, Professor.
Thank you.
Thank you, sir.
Thank you.
Thank you.